Regarding Ripple, an attorney who represents XRP is looking forward to a decision from the Securities and Exchange Commission. XRP Army members continue to be on edge as the legal dispute between Ripple and the United States Securities and Exchange Commission (SEC) continues. They are waiting for a probable verdict regarding the remedies and fines that are associated with the matter. As per the most recent regular filings, the legal process has been ongoing for 61 days and has now come to a close. Members of the community have tagged a number of well-known attorneys in the area who are associated with the XRP movement, including Bill Morgan and Jeremy Hogan, Jay Deaton John. The amount of conjecture that reached a high level in the community on Friday over the likely outcome of the XRP issue has reached substantial heights, according to the guesses of James Metal Aman Murphy and Fred Risby. This speculation has reached a significant and elevated level. I find this forecast to be very interesting. Taking into consideration the rumors, I am of the opinion that it might take place as soon as this coming Friday, which is one day before the anniversary of the verdict on this summary judgment, which is 1 year from now. With regard to my forecast, I will proceed with the placement of my money in the month of July, which is drawing to a close. One more thing to take into consideration is the fact that a knowledgeable expert is absolutely unconcerned by the mediocre performance of XRP and anticipates a huge breakthrough in the near future. This conversation was enlarged to include procedural challenges that would serve as a barrier to the eventual choice of remedies and fines. Bill Morgan, an additional attorney who is in support of XRP, joined the discussion and expanded it to include these difficulties. Annalisa Torres is the one who will decide on the conditions of the punishments and remedies, and she will do so by filing a request for information on the present state of a motion that Judge Sarah Netburn must resolve before making a decision. Morgan made the following observation in response to the query that was made by his colleagues on the matter on the subject. Judge Torres is the one who is responsible for deciding the penalty in the event that there is a motion that is currently being reviewed by Judge Netburn. The rise point that was provided was as described below. There is still a motion pending in File B. In accordance with the law, there is no requirement that it be known before that time. In recent times, Morgan has expressed his appreciation to B for providing an explanation, yet all he uttered was gratitude. It is possible that customers will argue to Netburn that with her discovery, there is no longer a requirement to decide the X for half-discovery issue. One or both of the judges might have the opportunity to interact with one another from time to time. XRP and Cardano, two cryptocurrencies, have been criticized by a former analyst at Goldman Sachs who calls to them as Cultman coins. Mr. Fred, please take a look at the article that is linked here. This discussion is in line with the most recent projection that was made by Riaspai, which Bitcoinists decided to include in their piece. Although Riaspai said that the decision might be issued on July 31st, he also mentioned that it could be made as early as July 13th, which is the anniversary of a significant summary judgment that was given down in 2023. According to Riaspai, the decision could be made as early as July 13th. The preceding ruling that Judge Torres made in which he stated that the XRP did not fulfill the conditions to be categorized as security, was a big victory for Ripple in its legal battle with the Securities and Exchange Commission. This victory was a significant victory for Ripple. In light of the aforementioned, Morgan brought up the fact that there is still a motion to strike that was presented on April 29th. This would make the process far more cumbersome, and he requested that the court take into consideration the summary judgment that was handed down by Judge Torres. The date of July 8th has been set as the deadline for the submission of the narrower request to seal, which Judge Phyllis Hamilton has established within the context of this Ripple XRP litigation. Cohen Gabe makes the observation that in order to accomplish this, Ripple Labs and XRP are required to conceal specific evidence that the court in Hamilton has acknowledged as being admissible. Ripple was provided with additional expert documentation by the SEC, which Ripple subsequently made accessible to the general public. Even though she was only recently hired as an expert witness, Andre Fox has already submitted her views and evidence, both of which are contained in these papers. The possibility exists that Judge Torres will be able to move forward with the case without the need for any more findings regarding this particular subject. If Judge Netburn issues a ruling that is favorable to this request, in regard to this request, the conclusion that Judge Netburn arrives at could potentially have significant ramifications. The parties involved in the Ripple class action lawsuit have responded to an order that was made by a district court judge not too long ago by submitting an administrative petition to file their papers under seal. This petition was submitted in response to the notice that was issued. The dates for hearings and motions were established by the court in the month of July, and the submitting of the narrow request to seal is scheduled to take place on Friday. Because the argument of the programmatic buyer is applicable to this scenario as well, this is the reason. Rispers Poyas proposed that this does not have to be a barrier to the decision-making process when it comes to the ultimate selection of the remedies and punishments that will be implemented in the case. Taking into consideration all of this material, a decision might be made as soon as this week in the form of an administrative motion to file under seal. The most recent documents that were provided to the court were an administrative motion in accordance with Civil Local Rule 7 of 11, as well as attachments to an administrative motion that were to be filed under seal. In addition, these documents were uploaded at the conclusion of the day, on July 8th, in front of this judge. In a direction that was sent out to the parties, Phyllis Hamilton instructed them to reconsider their petitions to have the briefs sealed. In response to a request that was filed jointly by Brad Garlinghouse, the court had earlier denied the sealing of any portions of the proceedings. This was the reason why this occurred, seeking that the court take into consideration the summary judgment that Judge Torres has already handed down. The date of July 8th has been set as the deadline for the submission of the narrower request to seal, which Judge Phyllis Hamilton has established within the context of this Ripple XRP litigation. Additionally, it was brought to the attention of Cohen Gabe that in order to accomplish this, Ripple Labs and XRP are obliged to conceal particular evidence that the court in Hamilton has permitted. Given that Magistrate Judge Robert Illman, who was given the subject, was due to meet with the subject in order to discuss the resolution of the issue, the meeting was scheduled to take place. It was also anticipated that the parties would submit a notification by the 26th of July, indicating whether or not they would continue to seek the exclusion of the testimony of 4 experts. This was to be done by the deadline. This was due to the fact that the plaintiffs were unable to provide evidence that XRP meets the criteria for a security and that investors are dependent on Ripple's efforts to generate profits. The court will then issue a second order regarding the more precise request to seal that was submitted by the parties when this has been completed. The majority of the domains that were covered by the summary verdict were ones in which Ripple emerged triumphant. According to a legal professional who specializes in cryptocurrency law, the price of XRP is expected to increase in the near future. In particular, the 13th of July is the anniversary of a historic judgment that was handed down by Judge Analisa Torres of the federal court as a result of Judge Torres' decision. This judgment was handed down as a consequence of Judge Torres' actions. It has been anticipated by Fred Rispoli, who is one of Ripple's advocates, that the court battle might be resolved by either July 31st or July 13th. Due to the fact that the 13th of July is the day that commemorates the anniversary of the verdict, this is a significant point. According to Ripple's advocates, Fred Rispoli had indicated that the anticipated deadline for order in the remedies phase could be either Friday, July 12th, or late July. This information was provided by Ripple's advocates. It is the advocates for Ripple that have provided this material. Now, in preparation for the eventual verdict that will be given down by Judge Torres in a short while, Wales is gathering XRP in sufficient quantities. Due to the fact that Whale Alert is keeping a close eye on this transaction, there is a heightened anticipation that the case is getting closer and closer to being resolved. The first day of the year has passed. When it was first made available to the general public for the very first time, XRP was an asset that was considered a commodity. As a direct result of ongoing concerns regarding the possibility of restrictions, the value of XRP increased by a factor of 100%. The regulatory framework that should be implemented with regard to cryptocurrencies is still not clear, and there are contradictory ideas regarding how it should be implemented.